anybody have any thoughts about General Counsel's suggestion that we put ourselves in a position to have outside counsel if as and if necessary, and the communication did come from the office. Attorney General through their regular counsel to us, and so do I have any comments or a motion here?
No, I'd like to make a motion to authorize the request to secure outside counsel as necessary pursuant to 114-2.3 and 147-17 based on General Counsel's explanation and obviously 101 Ethics Code that we're all upholding.
Do I have a second?
I'll second that, and then I have a comment, Mr. Chairman.
Okay, I'll accept your second, and Mr. Malcolm, please feel free to comment.
I just wanted to I not routinely, but I've had to exercise this process in my capacity here at the university. So I'm somewhat familiar with it, and it's my assumption, Mr. Lawson, because of quirk that's contained in 147.17, we don't anticipate, much like we didn't or not anticipating any problems from the AG's office. We don't anticipate any problems with receiving approval in an expeditious fashion from the Governor's Council regarding this, or do you know?
We've had no direct communication, but we don't anticipate any problem there.
Okay, great. Thank you.
All right, any further comments from the board? All right, we have a motion.
Mr. Tim Baker,
Yes, sir.
Mr. Tim Baker, just a question. Who determines what council would be retained, and how do we do that? The selection of council.
Jim, I think that's a very good point, because based on my experience here, as I mentioned, that's normally where there's some questions, and that's why maybe I should state my earlier statement or question to Josh Lawson a little differently. Josh, you don't expect that there's going to be any issues with the State Board of Election being able to select the council that we deem most appropriate to represent our interests, and we don't anticipate anybody from either the AG's office or the Governor's office questioning. It's really what I think is going to be our decision as a board, who we find to be competent and capable and without conflict to represent the State Board's interests, which I think, to my knowledge, is going to be a little unprecedented based on my experience with these types of requests.
Yes, sir, as to both points, it would be your direction as a board as to who we get a relationship going with. Yes, to the second piece, that they need to be competent, capable, without conflict. And then I would add only that we don't have any indication that there would be any problem encountered from either the AG's office or the Governor's office in us being able to secure whatever counsel we believe is appropriate in representing our interests, which are definitionally different than theirs, and that's why we're seeking outside counsel. But in any event, I believe that it would be in a meeting. The request, however, at this point, is only for us to seek appropriate authorizations. It's not to approve a particular representation.
Thank you.
Okay, we have a motion. We have a second. All in favor of the motion say aye. Aye.
Aye.
Opposed, no. Motion carries unanimously. Thank you, board members. Madam Executive Director, we understand you're going to report to us about provisional research with the Division of Motor Vehicles and use of maintenance databases under General Statute 163-82.14. If you would tell us what you have to report, I'd appreciate it.
Yes, sir, Mr. Chairman. I just thought the board wanted to update the board on where we are with in complying with Judge Biggs' order with respect to certain provisional voters that indicated when they presented on election day that they had registered to vote at DMV, but yet they were not on the poll book. That was a lot of research that was needed to happen between DMV and this office. A lot of work with teamwork went into making that process happen. It was a new process that DMV had never had to do in pulling. What they had to do is pulling from their database, not their voter registration database, but their large database, and trying to determine if people had visits. And then if they did have a visit, they had to see if that person had declined in writing to register to vote. So that was a lengthy process, and our counties have been very patient waiting for that information. But I'm pleased to tell all of you that as of Saturday morning, we provided all research to the county based on what DMV had been able to provide us, and then what we were able to do with those voters as well to determine their eligibility. And so all counties have that information and should be able to finalize their provisional. I think there were basically 1,000. I had Brian Neesby here, who was the actual person who did most of this work with DMV and here in the office. He could probably tell you specifically how many voters were involved in that.
It was $14.99.
Okay, so that is sort of an update on DMV provisional research. The second part that I wanted to talk about, we could talk about it now, or it might be more appropriate to talk about it after you have dealt with it. It also concerns some of the same questions that you're going to deal with in your next section, and that is how we deal with deceased voters, felons, voters that we might have information that come in late, how counties deal with that, how they deal with that uniformly. I think that's one of the questions you're going to be talking with when it comes to respect of the protest, and we can talk about that afterwards, or I can talk about it now.
I don't know how the other board members feel, but I'd kind of like to have a little bit of background on that before we consider the next item.
Certainly. A lot of our counties, there's a couple of what we call list maintenance efforts that our counties continue to do throughout the process, and that is when they get information that a person is deceased, the DHHS provides a report to the counties, and generally those reports, I'm told, come around the first of each month. And with that, with the election being what it was, a lot of counties were receiving these reports and then having voters that have cast ballots in the election were appearing on these lists. And so they have been seeking direction from us about how they remove voters that are deceased that have cast ballots. In addition, there are also, we have reports that we get from the Department of Corrections on a monthly basis to determine voters that may be felons that may need to be removed from the voter roll. And so that process, the way that process has worked since 2008, it hasn't changed since 2008, is that we get data from the Department of Corrections. That data is then matched with registered voters based on our SEAMS database. And then a report is provided to each county so that they can remove any registered voters. At that same time, we also have our IT division had created a database around that time period to take in data that was provided from DOC so that when counties are doing their provisional research at the end of an election, they can query that database to determine whether an individual voter is serving an active felon sentence. So, just to give you some background of why this is a real significance at this time, our IT director advised us on Friday that after he had seen some reports about protests being filed in the county regarding felons and deceased voters, casting ballots during the election, he said that he wanted to see if he could look at any data we had to test the validity of that. And so he looked into the database that is used for provisional research, queried that database, and was able to match some of the convicted felons with the voter roll. And what he did was, because there are several ways you could do matching, he matched the best match that he could do, because generally a lot of times first, last name, and date of birth is not always a good match. There are more people than you might think that share the same first and last name and the same date of birth. So we've not always found that to be a reliable matching criteria. So what he was able to do based on the data that's in that database is match on first, last name, date of birth, and driver's license. And when he did that, he was able to see that 339 people had cast ballots either during mail-in absentee or one-stop absentee, and they show an active felony conviction. So we're going to need to seek guidance on how we deal with that. Voter history is not in by the county, so it is we don't know at this time how many election day voters may also be in that, have cast ballots.
I have a question about this. As I understand it, if someone has who's on the felony list has registered, as I understand the maintenance of the database requires that you send a letter to them advising that the registration isn't accepted and they can contest this within 30 days.
Dr. Kruger, you're asking to have more letters sent to these people?
Well, as I understand, presumably, I don't know whether they did or they didn't, but as I understand, that's the procedure.
You're correct.
You can remove them. Am I correct?
You're correct. That is the procedure. When a county, pursuant to guidelines that they received back in 2008, the numbered memo goes through and gives them directions. And part of it is they do go and they flag the voter as removed in the database, but then they would immediately send a letter to that voter advising them that they have 30 days to respond to contest the fact that they are to be removed from the voter rolls due to a felony conviction. You're correct.
So would a voter who is on those rolls, if he has not received a letter, what's the status then?
Well, if these voters had been, if the county had received that, procedurally they would have marked them as removed, but yes, they would have received a letter. And these voters, because they have not been removed, have not received that notification.
This is Joshua. I've got a couple questions.
Go ahead.
So, Ms. Strike, just so I'm clear, and the public is clear, but most importantly, this board is clear. So, Mark Burris, on his own volition, came to the office and run this query. Is that correct?
Yes, sir. Mr. Burris, as I said that he saw in an article and that he knew that the database that they have created that counties are able to use for provisional research, that he decided to query that to see if there were felons in that database. Yes, he did that. Based on his, as he said, based on his hearing of those news articles, news accounts.
So, I think you've answered it, but I want to ask it just so it's clear. So, he ran that query, and I say on his own volition. I mean, he didn't seek guidance from you or our agency counsel or anyone else at the state board as to whether he should or should not do that. Is that correct?
No, I mean, he didn't ask permission from anyone, and he was not directed by anyone.
Do you know whether Mark Burris, or anyone else at our agency did that during the spring?
I don't think so, and I've talked with Mark, and he's not done that before. I think as he said, when he heard that article or those news accounts, he was disturbed by that there might be felons voting, and so he just wanted to check the database that he knew that we had that contained DOC data in it. And he said he had not run queries at that database before.
Mr. Chairman,
So,
the reason I asked that question, and I'm just talking out loud as I normally do, is some years ago, I had the good fortune at some point in my life to have access to a database that's referred to in North Carolina as the PCI database, which is a database that based primarily at that time, and I assume so now is used by law enforcement officials, that contains documents and records on individuals. And in that, at that time in my life, and I know it still exists now, the access to those types of databases are controlled by procedures and steps to ensure that the people that have access to those databases don't abuse that access, and certainly don't make decisions based on what a single individual may think he or she should be doing. And so, and the reason I bring that up is because I think, irrespective of this information that appears that we now receive, separate and distinct from that, I think Mr. Ock and this board needs to address that issue at some point. Because Kim, if you're telling me, if I understand you right, if you're telling me that this was all done based on someone's own personal decision, that concerns me. And I think we need to acknowledge that. If, like I said, separate and distinct from the fact that now we know. And I think that's important that now we know, Mr. Chairman, because now we can't settle. I mean, it is what it is. But I just want to raise that point, Mr. Chairman, because I think that's important for us to deal with at some point in the near future.
Thank you, Mr. Malcolm. I appreciate your comments.
Mr. Chairman, I just, this Lawson, in Mark Burris's regular course of doing his job, he has access as IT manager to many of the databases that we use to construct list maintenance procedures, and it is often the case that those folks are best positioned to determine how one database can be and should be queried with another. I hear the hesitation, but I certainly understand where the timing of this casts a shade on it very different. But if this was done not in association with an election or news of a protest, it certainly would have been in the normal course of his duties here, because that would be actually an audit that would be quite productive and useful for the counties and for the state.
Have we done that audit before, Josh?
Not to my knowledge, sir, and I wouldn't be, I wouldn't necessarily know, but not to my knowledge.
and I don't know either, Mr. Malcolm. I don't think we've done that kind of audit before. But we can certainly make Mr. Burris available to you if you want to ask him. I'm sure he would be happy to address any questions you had about it.
So
Sounds like the audit is a needed thing to me, Secretary Amoroso. Audits are generally things that need to happen in a business atmosphere, so it sounds like it uncovered some timely information.
So how do you suggest, this is Joshua, so Mr. Lawson and Kim, Mr. Chairman, if I may, so do you all need Are we hearing that you all need direction from this board as it relates to that matter?
On, go ahead.
I think Director Shack initially was saying that a question as to if we provided this with to the county, being a non-routine audit, the immediate question that they would have is what do we do with it? And the legal questions at play there overlap substantially, if not entirely, with what may be before you in the fashion of these protests, where it is alleged that there are individuals whose qualifications are in some way in question, but who have not been challenged, and the administrative processes would not have otherwise caught them prior to campus. So it's not that we're necessarily asking for an action step at the moment, but that it should play in the background as you make your decision regarding these protests.
So, I kind of need a point of clarification. So, considering they had not been moved previously from the voter roll and had not received the letter, would this constitute then a voter challenge to their voting? Is there a challenge to their voting? I mean, what's the status of this report? Is Mr. Burris challenging it?
No, the status of the report is that it exists as a file. There has been no challenge in terms of under 153.85. There is no active proceeding that involves these names of individuals, and this is only some quantum of evidence. But I think that your question is what is their status, and I think that's precisely the right question, because that's the same question that's being asked in these protests, just in a different form.
So Mr. Chairman, I think maybe, and Rhonda and everyone else, I think that sort of gets to the guts of this whole thing. I mean, we know that felons and other challenges are covered by 163-85, and we all know what it says in Rim A when it talks about the timing of challenges. And based on all these protests that we've received, I think that's sort of the crux of this whole thing, Mr. Chairman. And at least it's my understanding, or my hope, my belief that what we were going to do today is perhaps establish a time frame or a date certain for which folks could come before us and make their arguments as to how they think these statutory provisions should be interpreted by us before this board renders a decision. And at least that's what I was thinking, Mr. Chairman.
Yeah, I understand that, and I agree that that's what we're here for. So I think we can, a lot of the issues that have just been exchanged about the felony database, I think will be the subject of the next agenda item. And I'll invite you to the next agenda item, which is to address the request to assume jurisdiction over certain protests of elections filed with the County Board of Elections. And if I'm not mistaken, it was filed maybe late Friday afternoon with the State Board of Elections in Raleigh. I think it was distributed to the board by Josh Mountain. I'm sorry, by Josh Lawson. And there's also some issues that we received this afternoon that each board member received, and I think probably the best way to start this discussion is to have Josh Lawson sort of walk us through this sort of memo we received from Caitlin Love around 3:12 this afternoon. It sort of suggests some legal issues that need to be sort of discussed and some action taken by this board on this meeting, on the subsequent hearing that we'll be getting into here shortly in terms of timing, etc. But Josh Lawson, would this be a good time for you to sort of walk us through Caitlin's memo? And I will have some comments myself that maybe broaden it a little bit. But Josh, go ahead and give us sort of the background of the legal issues we're looking at. And then, again, it will be subject to further comments and additions or subtractions or whatever by any members of this board as we evaluate. We're not trying to make the determination of these issues today. We're just trying to determine whether these are the issues that will be discussed at this upcoming hearing, and subject to further comment by board. So go ahead, Josh.
Just to give kind of a flyover on this, you're right, it was yesterday afternoon, or Friday afternoon, that we received a letter from the Rocori campaign requesting that the state board take up jurisdiction in all of the pending proceedings down at the county level. I would note the letters that you receive, and sometimes we'll get them in the form of emails, and sometimes they're not from anybody associated with any action, but they will request the exact same authority be extended. They don't have binding legal authority. In other words, you're not required to hold a hearing. You're not required to consider certain protests within or without that the scope of that letter. But the board did notice this meeting as an emergency meeting for numerous reasons, one of which is that many counties that have pending proceedings are scheduled currently to proceed with those, whether they be preliminary hearings or hearings on the merit over the next couple days. So at a kind of 30,000-foot level, Article 80 of our chapter lays out a process of challenges. Challenges can be on the basis of any piece of a qualification to vote, from age to citizenship to felony status to residency. And there is a process by which challenges can be entered in time frames under which they must be entered under that article. Separately and apart from Article 8 is Article 15A, which discusses the process for protests. It assigns different deadlines and allows protests to arise on a number of grounds, but in two main categories in the first instance down at the county, and those are individual protests that regard the counting or tabulation of ballots. Secondarily, you could bring protests that would involve irregularities, misconduct, other types of things that you believe are wrong with the election, and under certain circumstances it may be necessary that you allege that their outcome determinative, namely if the county itself is the deciding canvassing body, and that all the races that you're protesting fall fully within that jurisdiction. For that first type, the type whenever it comes to counting the tabulation of ballots, there is a deadline associated with that. It's the day before county canvass. Those types must be resolved prior to the canvass for kind of reasons that would be pretty obvious to most folks. You need to decide the issues associated with the tabulation of ballots before you officially tabulate those ballots and certify a result. For the second type, you can file them till the noon the day after canvass, and you're able later then to bring subsequent appeals to the state board. And all of these, I should note, can be appealed to the state board in the regular course of a proceeding anytime that you have a final judgment from the county level. The request, however, that you received would involve your authority under 163-182.12, which allows this board broad jurisdiction to consider protests that were not filed according to proper methods. It allows you all to snatch up jurisdiction where you believe to be appropriate for undescribed reasons and reasons that may make sense based on timing or otherwise. It allows you also to bring your own protest type challenges and then kind of quote take any necessary action to assure that an election is determined without taint or fraud or corruption or without irregularities that may have changed the result of an election. So your authority is very, very broad. It would appear that the letter that you received via Director Strack, it was first given to Director Strack and then distributed to you on Friday, is asking you to do just that and take up authority. I have distributed to you all of the protests about which we are aware and have copies. There may be others, and there are at least 2 on our list that we do not have hard copies or scans of yet. These also may be at different points in the proceeding life cycle. There may have already been initial determinations. There may have been, and in some cases I know are, dismissals. And so the basic request is for you to decide what you would like to do with them for reasons that may involve timing of canvas, etc. But we're happy to help you walk through those issues to the extent it's helpful.
I'm looking at Caitlin's memo, and I think there were really 3 paragraphs there. One was Article 8, which you mentioned. One was Article 15, which looks like has addressed the different deadlines and grounds for protest. The third comment was what procedures should be followed to afford necessary due process while ensuring the timely and accurate authentication of election results. If you want to give me a Reader's Digest version of that thought.
Sure, yeah, this is Caitlin Love. So the requirements in the law are that any interested parties, and particularly the protester and any person whose vote is being protested, be given notice so that they can appear at any evidentiary hearing regarding that protest. If this board were to take up protests on the facts thereunder, the law would require notice be given to those individuals, interested parties, protester, individuals whose votes are being protested. So that's the requirement, and similarly to ensure due process, that people have notice and they're able to come and fully present their case before you.
Sure, Whitney, maybe I should give you a little bit kind of structured possibilities here.
Yeah, that would be good. Thank you, John.
You could certainly do what the letter asks, which is take up jurisdiction in full over all known protests. There are advantages there in that it may kind of prompt quicker resolution than working their way up through appeal. There are disadvantages in that there are likely to be and may already be protests about which we do not yet know anything. There could be future protests that are filed tomorrow, the day after, even though you're acting today. And then kind of as a secondary matter, just geographically, the presentation of evidence, if you were to take up these things in full, may be somewhat limited by the fact that, we're going to be sitting in Raleigh under a compressed timetable, and depending on the subject matter of protest, it might be more difficult for the individuals who are making those claims to appear before you, put on evidence, swear testimony, things like that. So that's if you take it all up. If you take none of it up, which would allow it to work its way through as is. That process, as you know, through prior proceedings in different cycles, has been a lengthy one and can potentially further involve, creation of documents of records, transcription of prior proceedings, and ultimately still get to you. However, there is the risk that you run that there's inconsistent application of the law across the state. that you may have individual protests on the same legal question being decided differently by different counties. And as we all kind of remember from Bush v. Gore, that's an equal protection issue, and we need to do everything in our power to ensure that each individual is evaluated on a fundamental freedom of exercising their vote, and that vote is counted according to similar standards for similarly situated folks. The other option you have is to do kind of a limited scope jurisdiction review. You could take up jurisdiction as to particular questions of law, for instance, about which the board could establish uniform standards. We could decide not to take jurisdiction over facts. In other words, say proceedings below that would be purely factual, and instead we could specify a number of questions that we think would be critical to a uniform application of the law across the state, accept briefings and hear arguments from interested parties on those discrete matters, and in that way we could ensure consistency and then remand for further proceedings as necessary in accord with whatever you decide. And if you were to do that, I think what you were referencing from Caitlin is an important set of legal questions, and I can just read them out from what she sent you. Is whether as a matter of law, county boards of elections may retrieve the ballot and discount the votes of an individual found to be ineligible, though no challenge was timely brought under Article 8 of the general statutes. And if so, whether the basis for determination of ineligibility may be brought as a protest of election under Article 15A, or through administrative processes pursuant either to 163.82.14, which is our list maintenance process, or 182.5, which is your canvassing authority and the certification that the election has proceeded without taint or irregularity. And then finally, if one's vote can be discounted and their ballot removed if ineligible, though no challenge has been filed, I think the question is then what procedures should be followed to afford necessary due process while ensuring timely and accurate authentication of election results. So if you were to take that third option being limited jurisdiction over protests that have a common question of law, say like deceased voters, felons, say their registration issues regarding mail verification and how far an individual has gone through that process by the time of canvass. That is another option before you. There's also a combination of all of those.
Well, my thought is that we need to address the three paragraphs, and this would be at this upcoming hearing. But in addition, I don't want this to be really a sort of a limitation. I think we need sort of a caveat that the State Board of Elections reserves the right to review and evaluate any action taken by any county board of elections up to the time of this hearing. And I guess that means that they may be continuing. They're having meetings, but I think we need to address those three items that in Caitlin's memo on the time of this hearing, but also leave the State Board of Elections with some certain flexibility to directly deal with matters taken up by the county board. So I'd like to kind of hear some discussion from other board members about their thoughts on this, and then your thoughts, board members. We can talk about the timing after we decide what we're going to talk about.
Well, certainly my thoughts are, I think it would be a mistake to assume jurisdiction over the protests that for most of the protests, and that instead we should provide guidance to the counties about how to proceed with the questions of how to count the votes that are in the protest. Overall guidelines, not specific to the actual voter.
All right, and any other comments?
I think, Mr. Chairman, I think this board should schedule a meeting to take up matters of law. As someone that served on the county board for 6.5 years, it would be a mistake, in my opinion, for this board to attempt to take up protests and matters on individual boards from 30 to 40, which probably by Wednesday, if this pattern of what I'm reading, the cut and paste pattern continues, it'll be 100 counties by Tuesday. I think it would be a mistake to do that. I think this board has consistently said in other matters that we appointed 3 members from all 100 counties because we felt them competent and capable to administer election matters for counties. And I think they need to make fact-finding decisions. And based on guidance in the areas of the law where things may appear ambiguous, for example, our earlier discussion about perhaps these folks now that may be convicted of a felony, perhaps these things now that are considered by some as challenges. And that would be my suggestion, is that we schedule a hearing, let everybody come, because they're going to show up, they'll know better than I do, and they're going to argue their points. And then we make some judgment calls like we're statutorily required to do. And if people don't like our decisions, of course they have recourse. But we've got to get on with this process. In my opinion, we've got to get on with the canvas. And I will say, Mr. Lawson and Ms. Struck, I can't understand why we don't know whether there are protests that have been filed in individual counties, because they're required to give us a copy of those protests within a day. And if people are not being responsive to our inquiries, somebody needs to get in the car and drive to wherever they are, knock on their door today and say, please tell me why you're not being responsive and following what you're supposed to follow. It seems to be perhaps what may have happened with this felony issue. So I guess it just seems like, and Kim, maybe I'm misinterpreting this, but the county boards have got to be responsive to what they're supposed to be doing so we can get on with this canvassing process. And that's my suggested approach, Mr. Chairman, is we schedule a hearing and let people argue the law to us, not facts about whether Joshua lived in or out of town. That's my suggestion.
Thank you, Mr. Malcolm. Either Rhonda or Judge Baker.
So this is Jim Baker. Just briefly, I think it is important that the counties be given some guidance in the legal matter. I do understand the logistical problem in trying to have factual hearings from all the counties in Raleigh. If that's being proposed or considered, of course I do see difficulties in that, but at the same time, I don't think can risk different counties reaching different legal answers with identical questions. And I see that as a great problem, and as was mentioned, before national situation, I think that's something we need to try to, in all manner, avoid if it's possible for us to do so.
Madam Secretary.
Well, I would echo Mr. Baker's comments, and I also, it's just very troubling to me how this all has developed. Right now you're looking at dead voters, felons, out-of-state voters, people voting in 2 or more places. Those are the 3 issues that I think came up on most of the protests that have been filed so far regarding tabulation error. To me, it appears, and it may appear to folks in the public, that we have a systemic issue here of voter fraudulent activity. And I'm very troubled by it. So what's the answer is the question. What do we do about it? And the first question posed in Ms. Love's memo is whether as a matter of law, the county boards of elections may retrieve the ballot and throw those votes out, find them, or those voters to be found ineligible. And if our board is making that determination as some sort of guideline, and I agree with the ability and the need for us to be consistent and let the counties go ahead and go about doing their business as they do, and then they can always come back up here and appeal it. I know it's going to drag out. It's already dragging out, probably longer than anybody would like, perhaps. But at the end of the day, and I've heard it from my colleagues over the last 3.5 years, we need to have honest and fair elections in this state. And we need to do whatever we have to do to make sure that that happens here. So I'm open to doing what makes the most sense, doing it doing the right thing for the right reason, based on the statute and the law in front of us. And I know we're all partisan, but we're non-partisan. But we need to follow this big bad statute book that's in front of us and do what's right. Should dead people be voting? No. If you voted in New Jersey or Georgia, should you be voting in North Carolina? No. Should your vote count? No. If you're a felon and you haven't been removed, should you be able to vote? No. It definitely is going to affect the outcome of several close races that are in front of us. And the sooner we get this stuff in order, the sooner the better. But again, I've heard this over and over again. If someone is voting and if they're ineligible to vote, then my vote doesn't count either. And that to me is troublesome. It puts a cloud over the integrity of the election process in North Carolina, in our wonderful state, and we need to figure out a way to resolve this, the best way to do it.
All right. Well, I sort of echo what I'm hearing from each of the other members. I think we have to really evaluate these three things in Caitlin's memo, and but I would continue to say that I think, just as a matter of clarification, so that we do have some flexibility as we are entitled to have, that we maybe if we adopt those three, that we're going to have this hearing and come up with some standards for paragraphs 1, 2, and 3. As long as we reserve the right to review and evaluate any action taken by any county board of elections up to the time of the hearing, that's where I would be, and I think that gets us to directly address these legal issues that we're all concerned about and should be concerned about, but maintaining some flexibility based upon what we see in the process. So that's where I stand, and if somebody would like to make the motion.
Mr. Chairman?
Yes.
I make a motion that we recess this meeting at the conclusion of our conversation today, when we finish talking about perhaps other matters, that this board reconvene Tuesday morning at 9 a.m. at a location to be determined by the executive director based on availability, to accommodate what I anticipate will be a large crowd for this board to take up establishing legal, clear guidance for perhaps unambiguous parts of the statute for interpretation of the county board to deal with these pending protests.
I second that motion.
Could y'all reread that? I mean, could you restate that?
Yes, sir. I'm taking out the part about us recessing. I'd make a motion that this board reconvene on Tuesday morning, 22nd of November, at 9 a.m. at a location to be determined based on availability by the executive director, for this board to hear, perhaps receive and hear verbally briefs from, as Caitlin said earlier, interested parties or folks that may be affected by the determinations that are made by this board. So we can issue clear guidance to all county boards of elections so they can adjudicate these protests through that clear guidance so they can complete their work as required by the statute to canvass and or deal with the pending protests that are before them.
All right. I'm okay with what you said up to that point, but I would, I mentioned about the State Board of Elections reserving the right to review and evaluate any action taken by any county board up to the time of the hearing. Is that something that you?
Yes, sir. That's absolutely fine with me if we
Okay.
modify
Yeah.
my motion to include that, Mr. Chairman.
All right.
I just get a clarification here because I'm a little confused. Up to and including the time of hearing at the county?
Well, no, up to the time of our hearing on Tuesday morning, that stuff, things have transpired at the county boards of elections up to now, and it appears that they will continue. They're trying to canvass or whatever tomorrow, and when I say up to the time of, I'm talking about the hearing that we would have, as Mr. Malcolm suggested, Tuesday morning, just so up to that point, we retain our supervision over the county boards for that. So that's the time of the hearing I was talking about, not their hearings, but this hearing that Mr. Malcolm just made a motion to have.
Oh, I see. I'm a little confused because they're holding hearings and perhaps making decisions. And are you talking about our doing an oversight of their decisions? Because I'm not sure that we can do that without an appeal from one of the parties. I'm sure we get one, but.
Yeah. Well, I'm not too worried about up to the time of the hearing. If you just want to say the State Board of Elections reserves the right to review and evaluate any action taken by any county board of elections and leave out up to the time of the hearing, I was just trying to put a time frame on it, but I'm looking for having these three legal issues to be determined, but not make that exclusive if there's some other action we need to take.
I agree with that, Mr. Chairman. I agree with that 100%. Michael, something may come up that hadn't been, the truth of the matter is our folks there in Raleigh have been working, it's my understanding they've been working 16, 18 hours. Caitlin, Josh, Kim, and the rest of them, Brian Newsy, have done the best they can to give us feedback where we are today at 4 o'clock on Sunday. We may just discover something tonight that we need to decide on Tuesday as well. And Chairman Whitney, I interpret what you're saying to mean if there's something else that comes up, we need to deal with it on Tuesday. So this may get on with this process.
Yeah. Okay. All right. Well, I'm sorry.
One other thing is that there's apparently been a board investigation of some issues in Bladen County. And in this instance, it probably makes sense for us to actually take jurisdiction there. So can we make the exception?
Well, my motion was not intended, and make sure I'm clear, I did not mention any county in particular. In my mind, my motion, supplemented by the chairman, says that we're going to take up legal matters. I intend to make a separate motion as it relates to my friends over in Bladen County to address the
okay.
Thank you, Brother Frank.
Okay. I'm gonna need a second to Mr. Malcolm's modified motion.
Second.
All right.
I'd like some clarification on what exactly Mr. Mountain's motion is proposing. If we're planning to meet Tuesday in Raleigh, who will be appearing before us? Who do you see appearing before us? Just counsel for the state parties, or PG and the governor? What is it, Mr. Malcolm, you're expecting to see happen on Tuesday?
Well, Caitlin, do you want to rehash your earlier comments about interested parties, people that are running for office?
Yeah, sure.
Oh, and other people, okay, and other type races. So it could be anybody, anywhere in any county coming up to Raleigh? Or just council of state races? Well, what are you talking about here?
So the statute regarding notice of protest provides that notice shall be given to interested parties.
If, however, you are not actually adjudicating those individual claims, and instead you're hearing legal arguments, I think that there may be an avenue by which you could limit certain types of comment to written comment. We could set up a portal for that. We could set up a process by which people could have written briefs with the question that we outlined earlier and can rehash if necessary. You also limit it to a lot more. In other words, if this is not something that you are actually adjudicating the rights, virtually everyone in the cloud that may or may not be over any one race, it's up to you.
Oh, I'm just concerned. It sounds like we're going to have a circus, and I'm trying to figure out what exactly it is we're trying to accomplish here by having something on Tuesday. We're going to be there another 12-hour hearing, but that's unacceptable. So I need to understand exactly what you're thinking is going to happen on Tuesday.
Are you asking me, Ms. Amarosa?
I don't know who I'm asking. I'm asking somebody who can answer my question.
Okay,
Because
well,
I'm also fuzzy to me what exactly, if we're just going to deal with legal issues and no evidence, no fact-based evidence on any particular counties, we're just handling the legal issues. Is that what we're doing?
that's my premise, is that we're hearing, obviously, the Cooper campaign, I imagine, is an interested party, the McCoy campaign, perhaps the two individuals that ran for state auditor. I imagine it's going to be a party, a political party,
Okay.
to say, at least in my mind. But on the other hand, and this is obviously me as an individual speaking, I don't want to extinguish anyone's belief that they think they've got something on their chest that they need to say, that we limit their ability or not allow them to speak, that may be perceived later as something that this board should have considered and what I perceive is issuing clear guidance. I imagine it will take some time, Ms. Amarosa. That's just me speculating.
Well, we've been together for now several years, and we've got to set some guidelines and time frames. Because you cannot have a kangaroo court, because that's we cannot continue to do that where you just drone on and you go for 12 hours without taking a dinner break. And then folks at the 11th hour get 2 seconds to speak. We've got to nail this down. I'm putting my foot down on this. Counsel somebody, Dr. Stratt, Director Stratt, we really need to put specific time frames like it would be in a regular course of law. We can't go on for an hour or two with one issue and then the next people coming up before us get 10 seconds. So if you can assure me that somebody there is willing to go ahead and have some strict time frame for the protester, or the petitioner, and the respondent, and then a rebuttal time, like a normal course, that might help us, because sitting there for 12 hours and having people go on and on and on, and after we've read through thousands of pages of documents, I mean, this is time and time again, and you're probably tired of hearing me complain about it. But I've read everything in here, and most of you have, and I don't need to have somebody come and rehash it. I've heard it, I understand the issues, and, we would take it under advisement or what have you. But to have a 12-hour repeat or rehash is really not fruitful for us as board members. So we need to figure out how to streamline the process and make it way more efficient than it is, and certainly affording due process to anybody who is due that.
Well, yeah, I think that we're not, again, hearing individual protests. We're simply developing guidelines. And what we're going to hear are people who have specific thoughts about or legal information that they wish to survey about guidelines.
Well, then perhaps those parties that are interested parties need to contact the State Board of Elections after this call and get themselves on the agenda or on the docket, so to speak. So we have it, and we can go follow it and stick to it.
I don't have
So
any.
it is a holiday week. We all know that Thanksgiving is Thursday. Might I remind everybody? And I don't know where people are. People are getting ready for the holiday. It always seems to happen this way right before either Christmas or Thanksgiving. Obviously, it's post-election. But I'd like to make it as simple and not chaotic for folks that, like myself, I have to travel a couple of hours to go to Judge Baker, and I don't. Maybe we could start at 10 o'clock or 10:30, so I don't have to come the night before. Some of us may already have, the holiday week, have family and stuff coming in. So I'd like to be as less disruptive as possible.
Josh, are you okay moving it to 10:30?
If that's the will of the board, Mr. Chairman, the only reason I suggested 9 is to somewhat address the concern, Rhonda, that I think you're bringing up, because I anticipated taking some while. And I too don't want us to be rushed. If we're supposed to hear from somebody, I want us to hear from number 20, just like we heard from number 1. So I agree with what you're saying now. That's the only reason I suggested 9 a.m. so we could get started and have a full day to hear the matter and hopefully be done in one day. But whatever the pleasure of the board is, Mr. Chairman.
Well, if you stick to some time frames, I think we'd be able to get it through. But, in the past, and Mr. Malcolm, some people we've let go on, the matter has gone on for an hour and a half. That should not happen under any circumstances, particularly since we've already read and digested the record.
I think, Ms. Amorosa, that may be what's a little different with this, however, because the truth of the matter is the only thing we've read in this case are these protests. So the parties, perhaps these interested parties, as Caitlin refers to them, they haven't had a chance to submit legal briefs. In my opinion, we've only got one, and it's the one we got today. The one we got on Friday actually didn't cite anything. So I think we need to acknowledge that, Rhonda. But if I were one of the parties, I'd be preparing a brief tonight, get it submitted tomorrow in advance so we could read it. But I agree with you.
Right, and I again, do not want to be reading 2,000 pages Monday evening. There's not enough time. And I know time is of the essence, certainly. But you can't expect us to read 2,000 pages and then sit through 12 hours of more hearings. To me, it's a problem. It needs to be worked out and figured out.
Okay. There's two things we need to pin down here. What time do we start the hearing? And I'm fine with any of the 9, 10, 10:30, whatever that you feel would Rhonda allow you to not have to spend the night or whatever. So I think Joshua said that that's the pleasure of the board, and as far as I'm concerned, whatever works for you works for me. I'm not speaking for anybody else other than I'm going to be there, and at whatever time you want to start. So go ahead and give me what time. Just give me a time, and I think we're going to be fine with that, Rhonda.
Well, I don't know, I'm probably going to end up coming the night before. It's a long trip. You know, it's a long trip for me, and then, you know, to sit for many, many hours. So I guess it's best to come the night before.
That was the next thing I was going to address. But let's kind of pick a starting time.
All right, how about, you know, 10 o'clock?
All right, 10, okay. I'm assuming nobody has a problem with 10. I certainly don't. Now, I'd like for Kim and Josh to help me best we can with Rhonda's concern about timing, and I think Mr. Malcolm actually agreed that he didn't want to be doing this for 12 hours either. But Josh, can you and Kim kind of come up with an agenda or a timing or even some time limitations so that this thing will not constitute another marathon hearing? Can y'all work on that so we can accommodate Rhonda and other people that have traveling issues, and so that we're not having people leave at 9 p.m. or something? What can y'all do to accommodate the board on that?
Mr. Chairman, we definitely, Josh and I, can certainly work on an agenda and some time constraints so that we do limit your day. It would be helpful for us, so if you could, the board could define for us the scope of the people that will be considered interested parties.
Well, let's start with the two campaigns, the McCrory campaign and the Cookie campaign. They need to be noticed and represented, okay?
Okay.
And I think I kind of like Rhonda's suggestion that if somebody else wants to speak, they should at least file a request or notice or something to get on the agenda, knowing that, you know, we're going to have a certain limited period of time for this, and that all requests to speak should be in writing. I'm not trying to cap off anybody speaking, but I think we need to be very careful about how much time people are given because of this issue that we want this to be a hearing that covers all the issues we need to discuss, but at the same time not run on forever into the night. So I would defer to other board members about who else might be allowed to speak or should be necessary. And I think we do. I think Mr. Malcolm is going to have some discussion about Bladen County here momentarily.
Mr. Chairman, we believe the board would be within its authority to limit the presentation to candidates and recognized parties, given that these are broad legal issues that statewide, as opposed to legal issues raised as to one particular protestor's interest.
Okay. Does any board member have a problem with that?
I'm just thinking about if there's any legal representation from counties that might want to put in their 2 cents.
I would certainly agree with that, Dr. Cricker, that not necessarily call the counties by demand from our board, but certainly allow them to appear as soon as they advise us, like I said before, in writing.
This is Jim Baker. I have a concern about that as well. And Dr. Picker was brought up this point. Some of the legal issues we will be debating, I assume, will possibly involve some action to be taken by a county group. I'm thinking like Bladen County and other areas such as example. So how could we have a hearing really on the actions of those groups concerning legal issues raised by the actions of those groups without those groups being allowed to even participate?
Well, no, clearly I want to allow them to participate. The real question is, should we require them to have a representative there if they are one of the counties that's subject to a protest?
I don't think we should require anyone to be here if they don't want to.
Okay, well, that's fine. All right, well,
Could I
then,
ask you, sir, that we're talking about having a meeting on Tuesday morning and this is Sunday, and that means notification and preparation by all parties has to be done tomorrow.
Would it be done tonight, right, Josh Lawson?
I would assume so.
Yeah. You guys are
If people, if everyone, if all interested parties find out about it,
right. Well, I wanted to just take the time here to recognize and I'll take my chairman's discretion, but I'm a personal witness to the dedication of the staff. I was actually at State Board of Elections headquarters both Friday night and again Saturday morning, and Chairman Strack and the General Counsel Lawson and others were there burning the evening oil, and then up Saturday morning. And I want to thank them for their service and for their dedication of giving up their weekend and perhaps a lot more than just that, so that telling the public is how hard they've been working to address all of the issues, including the ones that we're dealing with today and we'll deal with on Tuesday, but certainly a number of others that maybe we don't even know about. And I personally want to express my gratitude to each of the members of our staff. So that's my chairman's prerogative. But we're back to certainly, I guess Kim and Josh, if we notice out the two campaigns, if we notice out each of the counties, right? County Board of Elections.
For possible written comment.
Written comment.
I'm sorry.
The counties, there has been a mention of written comment. Is that?
Well, no, no. What I meant was for the counties to advise us in writing that they were going to appear. I really don't. I'm not too worried about that. If a county board of election person shows up, then I'll give him or her adequate time to speak. But I think we had just talked about what Rhonda had mentioned earlier in that we should at least know ahead of time who's going to speak, and it's common courtesy for those people to just kind of let us know so that we can try to make sure that the timing is right and allocated among the time frames that Josh and Kim are going to come up with. It's just planning so that we don't replicate the 12-hour hearing.
But we're not, the hearing on Tuesday, Mr. Chairman, is not for these 54 counties to come before us and talk about the fact of their dead voters and the felons. It's a general issue, so I don't know that they are interested parties, so to speak, in that sense. But I think if they want to weigh in writing, they should. And by the way, if they're all canvassing tomorrow and the next day, they've got a lot of work to do where they are. I don't want to encourage them all to show up in Raleigh when they need to be taking care of business down in their own county.
Well, in that case, as long as they're aware as long as the county boards are aware that we're having this hearing Tuesday morning at 10, then they can decide if they want to, participate. or,
Right, but they need to understand it's not substantive, factual issues from their particular county. There's no need for them to drive
Right.
6 hours for 10 minutes. They need to understand
Okay.
what it is we're doing. I just need to be very clear
Yeah.
for the folks down here.
well, I think Kim and Josh can make that clear that,
Okay.
that they're welcome but not required, you know.
They
Just
do
a-
need to be on the docket ahead of time.
Yeah, that part, I would say is appropriate, so that just so we can plan the meeting and allocate time frames and discussion among, you know, whoever decides they want to show up, but obviously we need the two campaigns there. So,
Without meeting on Tuesday to be considered by any county as a reason not to proceed with their canvassing. I know many counties have meetings scheduled for tomorrow.
And Judge Baker, this is Josh Lawson. That is, in my view, something that is maybe even more important than who's getting to speak, is that we need to understand as staff the scope of what you're doing, because half the counties are going to be canvassing through tomorrow and by the time that you meet. And so if your determinations of law affect that, we need to know whether you want us to take any steps ahead of time on that. If they don't, that's another matter. Or if you're wanting these proceedings to continue below on facts, even the ones that you're considering the legal justification behind, if you're wanting those to consider on facts, that's a substantive question as well, because they're going to be holding those hearings additionally over the next 2 days. So I just want to make clear on scope on what you're wanting us to say that we're doing. We're taking up a legal question because of these protests. I'm hearing that we may not be taking up these protests, but I want to make sure that we notify the counties what we're doing and notify the public what we're doing, because if it is a long 12-hour meeting, that means that what they get by way of a response won't happen until late Tuesday night.
Which means presumably that they need to delay their hearings and possibly their canvass. I assume.
And that's going to be up to you, as well as the issue that Director Strack mentioned earlier about this list that would involve counties that have no protests going on right now, and whether they may have to subsequently recanvass in line with whatever you decide. But these are determinations that do need to be made as part of this motion, in addition to the scheduling.
Hey, Josh, can we handle it this way? Mr. Chairman, can we direct, because I know the statute allowed all these counties, and I think this is part of it, I think it's problematic statutorily. It says that the counties can delay their canvass for a reasonable amount of period, which of course creates this ambiguous, and perhaps that's why Wake County scheduled their canvass after the state board canvass, which to me is absolutely perplexing. Maybe you can explain that to me later. But do we need to instruct counties that do not have current protests, which means our discussions about law, there are no protests, shouldn't be germane to what's going on in those counties? Is that factual? Do you agree with that statement? If there's no current protest in a county, the discussion we have on Tuesday, do you agree or not agree that it may be germane to them proceeding with the canvass related to what was...
So my concern, Mr. Jim Baker, my concern is that our ruling on some legal issues may be considered as grounds by some parties whether or not to file for it.
I'm sorry, could you say that again, Judge? I
Well,
didn't hear.
I think everything the state board does will be closely examined. So if we decide that certain legal issues are significant and need to be dealt with, that may affect some group in some counties as whether or not to file a further protest. I hope that makes sense.
It absolutely does, Judge. That makes sense to me the way you just framed it. And with that being said, then why don't we direct all counties to hold we direct them to not canvass until we hold this hearing, make these determinations. determinations, and then people have as clear guidance as they're going to get. And when the people get upset with our decisions, it's obviously some people are, they got recourse to bring our judgment into question should they decide to do so. I agree with that, Judge.
So, just from a timing standpoint, that direction will be available sometime late Tuesday, presumably.
Could I ask the chairman or council what they think about these issues, about what effect our meeting might have on county boards and the actions they're scheduled to take? Do they need to talk, or do we need to more carefully determine what we're going to be doing on Tuesday?
Well, I would ask Josh to address that.
Mr. Chairman, Judge Baker, I think that if Mr. Burris had not run that list and we were not needing some direction from you all on it, I think it would have been appropriate to make this matter a little bit more defined. But as it is, I think that if there is the existence of this list that covers the entire state, then you will just have protests filed tomorrow in every county in which there's not a protest. And so you would be stuck in the same position. So if you are intending to stay campus, that's a really big deal. It would stop all these proceedings that could elongate this process. It would, however, ensure uniformity. And I know that all we have to do is kind of weigh those factors, which are significant. So what I'm saying is that to narrow any type of stay of campus may not be one that would, last longer than a couple hours after this meeting, and it's more well publicized that there may be problems in other counties that don't have current protests. But that's going to be up to y'all.
Well, one of the questions I have, there are time constraints on when you may file a protest. And I believe that's passed.
Is that a question you're asking staff to clarify?
Yeah, I mean, yes, we can, hear, I guess, or agree to hear protests that are not timely. But, I'm just, wondering if we need a motion about whether we'll do that or not. And yes, I would like to ask the comment.
Well, I, if I'm not mistaken, I think what you're talking about is one of these three legal issues that will be argued and possibly briefed on Tuesday morning.
Okay.
In my mind,
So I think that's the very thing we're trying to get to, Doctor. And so I think your question probably better not to answer today with the internal opinions, but let the issue be briefed and argued by counsel, and then you'll be in a good, better position to make your decision as to what the application of those statutes ought to actually be, or how they should be applied. So I think that's why I'm saying I think we'll have an answer to a number of these things by Tuesday afternoon. Hopefully not too late.
Dr. Cricker, the deadline for filing a protest that concerns the manner in which the votes were considered tabulated is before the beginning of the county canvass meeting. Some counties have already begun their canvass process, although they have not finished it. Other counties have not yet started their canvass, so protests could still be filed. Additionally, there's an exception to that rule if there is good cause for not filing the protest in time for the county canvass. A protests relating to the manner in which the votes are tabulated and still be filed by 5 p.m. on the second business day after completion of the county canvass. So, whether a good cause would be that the information was not available until a later date would be a question.
Well, there's another statute that we'll have to deal with as well that talks about the irregularity statute, and that is after the canvass. So either way, it's going to be a circus. I hate to keep using that term, but it's not going to end anytime in the near future. So I think we proceed as we're going to proceed for Tuesday, let the canvasses go forward where there are no issues, and let the chips fall where they may, and if people want to protest post-canvas, as is always the case, we've been there, done that. That's it's in the statute, so.
So did we vote on, Mr. Chairman, did we vote on, I think we need to vote on the matter of holding this hearing on Tuesday at 10 a.m. I know there's a motion.
Did we ever get?
We did not, Mr. Chairman. We did not.
All right, somebody needs the second, Mr. Malcolm.
I did second
Well,
the
you
motion.
did before it was amended.
No, I did after also.
Okay, good. Well, I'll accept that as a second. And so we have this motion. Any further discussion by board members?
Just quickly, this is Jim Baker. I'm going to vote for the motion, but I'm not voting for the motion as an alternative to the state board having the ability to exercise its right to take jurisdiction over a county issue should we determine for some future reason that we need to do so. I'm not considering it as an alternative motion, I'm considering it as a method for us to resolve legal issues. I don't want to limit our ability.
And that was my intent, Judge.
Well, I think that was my caveat that I think Joshua agreed to.
Okay, now I understand it. Yeah. Better.
Anyway, okay. Well, all right.
Mr. Chairman, just for the benefit of staff, just to make sure that we're clear on your motion,
Yeah.
if that's okay. You are going to decide a legal question on all protests about which we have record, which involve absentee fraud allegations, deceased voter, felon, interstate voters, SDR provisions, sample audits, voting systems. You are not staying, or you are staying further proceedings on those pending protests at the county level, and therefore staying canvass for those counties.
I believe Mr. Malcolm had sort of modified his motion to that effect, and Dr. Cricker, I assume you're on board with that, right? On your second.
Yes, with the understanding that a separate motion is going to be made about Blaine County.
Yeah, well, that's coming. That's coming.
Okay.
Rhonda, do you or the...
So wait a minute, you're staying canvases on the protest counties. Is that what I'm hearing?
I think that's what you're hearing.
All right, well, I have an issue with that, but go ahead, you can proceed.
Well, all right. What is your issue?
I'm just opposed to that. I think the folks that are going to go canvass, let them go ahead and canvass. If they can work it out and canvass, and there's no issue, and there's no protest, then that's one less county that we have to worry about, no? Unless I'm not understanding.
Rhonda, I think what you said is accurate. Judge Baker, correct me if I'm wrong, sir. You were the one that brought up the issue that perhaps some of the legal matters that we decide on Tuesday, where we issue perhaps what I hope is clear guidance, you're of the opinion that that may affect counties that that currently don't have a pending protest. Is that correct, Judge?
That was a concern I expressed, yes. I recognize that tomorrow, many counties will be meeting to resume or to begin their canvassing. And if we are meeting, that we will deal with some issues of our decisions might influence whether protests are filed or not. And I understand there are the timelines of the 163-182.11 and then 182.12. But I was just raising my concerns about that.
But what's your opinion? Is your opinion that...
It's time trying to predict the future, really.
I think what we're trying to get at is does the motion include a stay or not? And I think Mr. Malcolm was trying to accommodate your concern, Judge, but I didn't know if you were asking him to include the county board's canvases would be stayed or not. If we don't say something about it, Josh Lawson, they're not stayed. Is that, and they keep going and doing what they would have done anyway, and we can go back at the tail end if we need to, and if their canvas is inconsistent with our guidelines, that they could fix it then. I'm throwing out the possibilities. I'm just trying to figure out exactly what the motion is and whether Judge Baker wanted that added to Joshua's motion or not.
So parties still have an opportunity to file a protest after the canvass. I think it's up to 2 days, if you correct me, counsel. So there's another fail-safe, if you will, if there is another problem. We've seen that before.
I do have some concern with putting a halt to all this, since we do have a backdoor remedy of making them comply even after they've done it, and I'm just wondering if they're starting this stuff tomorrow morning at 8 or 9 o'clock, whether it's that they can be continuing the process of what they're doing, rather than, and if their activities are inconsistent with the resolution we come to on these legal issues on Tuesday afternoon, then they got to meet again or fix it, or hopefully, they'll do it correctly. But I think I'm with Rhonda that it concerns me to put a halt to something that's already got a lot of momentum and probably got a lot of people that plan their week to deal with this. And the judge,
I'm not asking the canvass to be halted.
Okay, all right. Well, then,
I was just raising concerns that I had about our action.
okay. Well,
How that would be needed.
yeah, okay. Well, then I'm going to assume that means that the motion does not include.
Yes, sir. That's
Okay.
correct.
Thank you. All right. Okay. Well, Josh Lawson, are you?
Right, so the motion does not include a stay, right, which would be required unless you were fully taking jurisdiction of these protests. What I'm hearing is that you are not taking full jurisdiction of these protests. You are instead holding a separate meeting parallel to the protest proceedings below, in which you will determine legal answers and guidance that would be substantively useful, but will be issued on Tuesday night or some point thereafter, and may be retroactively applied to those that have been resolved by that time. Right? Just want to make sure that...
Does anybody disagree with the statement that Mr. Lawson just made? that that's what the motion is? Because I think that sounds right. Well, hearing none, I assume that Josh Malcolm, that Josh.
That's the effect of it, Chief. That's the effect of it, Mr. Chairman.
Okay, that's fine. Okay, we have a motion. We have a second. All in favor of the motion, say aye.
Aye.
Aye. Opposed,
Aye.
no. Well, I didn't hear any no's, so that motion passes unanimously. So we'll reconvene at 10 o'clock on Tuesday morning. Now, Mr. Malcolm,
Yes, sir.
we would like you to address Bladen County and the issue, whatever.
If I can just ask the record just a series of 2 or 3 questions, and then I'll be ready for the motion. Ms. Strike, is it true that state board staff has been deployed to Bladen County to investigate allegations related to the most recent election?
Yes, sir.
Is it true that you've been in constant contact with those folks as to what they've learned during the course of their investigation?
Yes, sir.
And is it true that what's been reported back to you rises to the level to create concern in your mind to whether inappropriate activities by individuals within or perhaps outside the county, whether things like that have occurred?
Yes, Mr. Malcolm.
Mr. Chairman, in the interest of keeping the active, what may be perceived as a criminal investigation outside the purview of the public, it's my recommendation that this board exercise its authority under 163-182.12 and take jurisdiction over the allegations known and unknown that are occurring or have occurred in Bladen County as it relates to the most recent election on November 8th.
Thank you for your motion. You have a second.
Second?
Okay, any discussion from any board members?
Well, no, I'm just wondering if Durham County should not also be included in this motion.
And Secretary Amoroso, I am aware that at the county level they have filed notice of appeal, which they have to do 24 hours after a written order from the county. And so it may be that is in fact headed your way anyway.
Okay. I know there was some major issues there.
So let's do this. Let's vote on Bladen County, and if Secretary Amoroso wants to make any further motions about Durham County, we'll do it in the next 5 minutes. We have a motion. We have a second. Any discussion about Bladen County? Hearing none, all in favor say aye. Aye.
Aye. Aye.
Aye. Opposed, no. Mr. Malcolm, motion carries unanimously. Rhonda, do you have any further comments or?
No, I would sort of echo the same motion that we just passed for Bladen for Durham County in light of the issues and absentee ballots and all of the problems that Durham County had encountered election night.
So do we have reason to believe that criminal activities occurred in Durham County?
They may have. I don't know. I don't know where the matter is. I haven't seen the facts. But there's enough out there certainly to suggest something occurred, and it's giving me pause. Now, Josh Lawson, you're saying they're in the process and coming up to us. I don't know. I haven't seen it.
There are 5 filed protests in Durham, one of which has been heard to my knowledge, and they may have had a preliminary hearing on others. The main one that has gone to a hearing on the merits, in which our staff, Brian Neesby, was subpoenaed to testify, that was unanimously dismissed by the county board. But my understanding is that the petitioner has noticed an appeal with them, which they're required to do, and then they have 5 days to actually continue their appeal. I don't know.
Well, if it's coming up to us anyway, we may want to think about it in the jurisdiction in Durham County, particularly since they have been without a director now for some time. I'm just concerned, and I think we ought to look at it and give it its due course. It's the same way we just did for Bladen County.
If it's coming up through the regular appeals process, that gives the parties opportunities to formalize on what basis they wish to appeal, and then for the opposite side to counter. If you were wanting to extend jurisdiction now, we would have to kind of tweak that process. The alternative is that you could wait and see if they filed by Tuesday, and then the normal process would run, and you'd still get it at the same time.
All right, why don't we wait or reserve until our meeting on Tuesday, see where they're at, unless somebody would like to assume it today.
No, I think that's better. I kind of like it to go the usual way, or standard way, if it's going through the consent basis. That would give the parties more clearly defined rights in terms of the rest of the review. If it's coming to us anyway, let's let it come to the regular round.
All right, any further discussion? Anything else within the state of North Carolina? Well, in that case, I will, hey, Josh, have I hit everything on the agenda?
You have, sir, and you would not, however, you would ignore that last piece which says to adjourn. You make a.
I'll enter, well, we've already had a motion.
You're right, I'm sorry, sir. You have held it. You decided to hold open a reconvene back at 10 a.m. on Tuesday at a place to be recommended.
So a motion to adjourn is not really in order.
You're right, sir. I misspoke.
The only thing that's in order is to say thank you for all the citizens who have listened in, and we'll be back in business on 10 o'clock Tuesday morning. And I thank all the members of the board and all the members of the staff for their dedication and their service. And have a good time and good evening. Goodbye.